just
Yes,
in
please.
reference to Drew's comment there, all of those credits that are attributed to the contractor during the construction phase also have to be addressed in our drawings and specifications. If they're required to do an IAQ management plan, if they're required to include a certain percentage of recycled content, those things should be identified in our plans and specs as well. So that's, feeds right back into Hobbie's point that these people clearly met their contractual obligation by satisfying the plans and specs, and we need to make sure our plans and specs also include those requirements.
So what is the result?
It's settled. So we don't know. We don't know. And that's the odd thing about this. We don't have any appellate court decisions on any of this. We just know what people have been grousing about. The courts haven't had an opportunity yet to drill down. But when the courts do look at these, they will employ the typical contract rules of the road. We just have a new set of criteria out here that these will be applied to. Someone had it. Yes, sir.
I'm not sure if it's the right time to ask this or not, but you can do everything that you could say that I'm trying to attempt to get every point that I'm trying to, but then it goes to the Green Building Council. They could say, yes, you have, or no, you haven't. So you've got somebody that's outside of your immediate control that's ultimately deciding yes or no whether you met that.
You hit the nail on the head. And that's why, in my opinion, it is a mistake for a design professional to agree by contract that they will deliver a platinum certified building or a platinum certified design or gold or silver, because you can't guarantee what that reviewing authority is going to do. One of my favorite words in contracts, not as a wiggle room or as an escape liability room, but as a practical and pragmatic rule, is endeavor. We will endeavor to get you that platinum certification. We will do our daggone best to get you there, but I can't guarantee it because I can't make that decision. That's a very good point.
How would you respond, because this is something that everyone on the insurance side is still concerned with, knowing that we don't want to guarantee and say we will provide a silver, gold, platinum. On the public side, the GSA, the public body, many of the contracts say you will provide a silver certified building. What do you feel like is going to be the impact of that?
I'll tell you what I think.
Because the insurance
I'll tell you what the impact is. If you agree by contract to deliver a gold certified building and you don't get it, in my opinion, you're sued for whatever damages come from that. In my opinion, your professional liability carrier is going to deny coverage. You will owe on the obligation. Your firm will be liable. You simply won't have the financial backstop of your insurance company to help you. And this is a comment, I think, that belongs as much with owners and developers. In my view, and when I counsel owners and developers, I tell them to make sure that the coverage is in place. Don't ask, it may sound great to have somebody's feet to the fire, but if there's no financial heft behind it, it's a hollow promise. So when you enter into these contracts, make sure it's something the other side can deliver on if they fail in their ability to perform as you want. So entering into a contract like, and the government is as guilty as overreaching as anyone in any number of different situations. And understand what insurance companies are. They're not charities. It's not the First Presbyterian Church. They are not there to be generous. An insurance policy is a contract. They agree that under certain circumstances, they will pay. If your case doesn't fit into that set of circumstances, they have no obligation to pay. And for as many attorneys as they hire to defend their insureds, they hire attorneys to take a look at it and make a coverage opinion of whether they have a duty to pay money. So it's a wonderful thing that we have, but those on either side of the equation need to be mindful of what the contract provisions might do to that coverage. And I think everybody wants it there. It's not just to protect the design professionals. Good golly, if I was an owner, I want to know all that coverage is in place. And I want to know if I'm overreaching in my contracts such that I'm going to compromise my ability to collect.
One of the things that concerns me, though, is probably more than anything else, is that, I mean, Hobbie has given us absolute wizard quibble language on weed and certification.
Now, he used that word, I did.
Yeah, as a former bureaucrat, I can't do that. But, I mean, and it's great. It's I think, very, very, very well written. It goes into every proposal we send out here. But my concern is that, okay, we've said whatever we said with our agreement with the owner and all that, but then the owner's brokers, or perhaps even the owner themselves, comes in and they're signing a lease with XYZ Corporation. It's like, oh, yeah, this is gonna be silver all day long. When, you know, we've covered ourselves, but, you know, there's always collateral damage. And in that case, I would think that it would be between the tenant and the owner, but, you know, shrapnel, you know, goes in a lot of
Stuff
different
flows
directions.
downhill. Nobody
Yeah.
likes to take a hit if they can pass it off on someone else. If a tenant comes in expecting that his utility costs are gonna be less because of the LEED certification, and if those promises, this is generally if those promises have been made by the owner, this is what you can expect. This 2,400 square foot unit is gonna be 40% more energy efficient than the building you are living in. If you make those kind of promises, those kind of contractual guarantees, then an owner can be clocked by something like that. And if the design professional had made similar promises in its agreement, these are the life cycle costs that you can save. These are the energy costs that we project you will save. And look at my studies here. We all know that a design professional can't guarantee that because you don't know what the weather's going to be like. You don't know what the owner's maintenance is going to be like. You don't know how people are going to be using the systems, whether they're going to be maintained properly. There are so many variables that suggest that those kinds of guarantees are only foolishly made. And I shouldn't say foolishly because that's when we get involved and have so much fun. But it is I think it's a mistake to enter into those kinds of contractual agreements because they're enforceable. And if you breach them, you've got to make the other side whole.
5 minutes.
Oh, okay, I'll go through some of this stuff rather quickly. I'll skip this one. It was, there's some other curious yes, sir?
Okay. I'm the owner. I came to architect. I says, I want to go leave. And you cannot, the architect cannot says, well, I cannot promise you. Then I go to next architect. I go to next architect, who promise? And the architect has to tell the owner, if you want to go leave, then you have to listen to us. And whatever we explain to you, whatever we tell you, you have to do it. Otherwise, once you deviate from that, we cannot promise to go leave. But if the client say, I want to go leave, yes, we can give you, but you have to listen.
I think it's fair to say that no matter how bad the contract, there's somebody who will sign it.
But I'm saying, we can put a language that architect has a right. Or something will tell the owner that you need these components to get the go leave.
I see.
And if you
Yes.
don't follow that, he said, I don't want to do this one, so then we are off to go leave.
I agree with you entirely. I think that there is a big educational process that goes on between, or that should go on, between architect and owner. The owner has to know what can be delivered by the architect and what it's going to take. The give and take of that exercise to accomplish the owner's objective. Remember, that's what we're trying to do. The owner wants something and they're paying us a lot of money for it, whether we're the contractor or the architect. But we have to educate them about the process, what we can promise, what we can deliver, and what we can include in our contract. We've got 62 gold certified buildings. We know what we're doing, but I can't guarantee it because I'm not the reviewing board.
What I'm saying that as architect can guarantee, but has to put a language in the contract, tie the owners to make sure he has to listen and he has to follow the architect's recommendation.
That is a way to address it.
He cannot deviate.
Can I hire you? Will you be my consultant?
Nope.
Can't have it. Sorry.
A couple other interesting claims that have come out of this. Cork floors, kind of a popular thing. Well, it turns out that in the right environmental conditions, they're sort of mold traps. And they had to rip out all this great eco-friendly stuff and put down linoleum. One of my favorites, a university had these spectacular windows with this fabulous mechanical system that was to have great things with recirculation, introduction of fresh air. The problem was the pigeons like to poop near the fresh air intake. So they created all kinds of unpleasant interior conditions. I thought that was pretty nifty. Water and roofs. Roofs are great. Green roofs are wonderful, but the problems that have come out of these green roofs are everything that you would anticipate. Whether or not roofs are great because you get a ton of LEED credits up there, but there are a boatload of problems that come from putting something up on your roof that requires water. It's pretty tough to maintain stuff underneath the sod and all that kind of stuff. You have a lot of water migration issues, mold and stuff. But here's the funnest part. What would you think would be the biggest risk about having grass on your roof? We've had a whole bunch of these, a whole bunch of different concerns, and I've touched on some. Fire. Zurich doesn't like these roofs at all because they think they're fire hazards. If you don't water your roof, it's a fire hazard. So they've had in Europe, not in Europe, over in England and Scotland, they've had issues with respect to grass roofs, and the concern is they dry out, and kids will be kids. If kids get up on that roof and they're playing with matches, we could set the thing on fire. Kind of fun. We've touched on a lot of stuff. I went through rather quickly at the end. I know Kathy has. We would be pleased to entertain any questions you've got, or if anybody has some good lawyer jokes or insurance jokes. Yes, ma'am.
I have a question. We had a project where we struggled, for reasons not our fault, to get the final couple of LEED credits to get us to LEED Gold. Luckily, in the end, we were able to get there and get the certification, but the client took our LEED scorecard, and I don't know if you're familiar with what the LEED scorecard looks like, but there's a yes column, a questionable column, a no column, and said, you said yes to these credits, you promised me all of these credits. Do you think that that's a valid argument, and is there, should we be covering ourselves in some way when presenting these scorecards to our clients?
That's close to one of the issues I mentioned before about certifications and working with the agencies. I think that is a possible claim, and the way you can address that is by presenting that as a statement of your professional opinion. And here's why. That there is a quirk in the law between statements of fact and an opinion. A statement of fact is something that can give rise to a claim for misrepresentation or for fraud. What that is a statement of fact made with the intent that it be relied on. It's relied on, and someone else is damaged as a result of that reliance. The courts distinguish a statement of fact from an opinion, and they say opinions are opinions. We've all got them, but it has to be a statement of fact to recover under that scenario. So, in my view, because all they are is expressions of opinion, that it should be transmitted in that way. That we've prepared this, that the statements are a codification of our professional opinion. And I think that would go a long way to relieve that concern.
Great.
It seems like we should have a disclaimer on that checklist.
We do now, and I need to run it by you. I think it doesn't say professional opinion.
If everybody listens to me, I'm going to be out of a job.
I think a good point that if those in the office that are working on a LEED project, we do have scorecards in the office that are formatted on our letterhead and that have that disclaimer. So please don't be just pulling off of the websites and using their documents. Use the ones that we have.
Right, and
inside of our office.
I'm going to joust with you a little bit on disclaimer. I don't think it's a disclaimer as much as it is an accurate statement of what you're doing. If any way you slice it, that's not a statement of fact. It is an expression of your professional opinion as a qualified and talented design professional. But it is your professional opinion. Somebody else is going to decide whether to give it to you or not. So it's professional opinion, in my professional opinion. Yes, sir.
I'm just a simple commissioning consultant. Increasingly, I'm being asked by owners to do what I consider forensic commissioning, where we go after commissioning of LEED projects.
Oh, I need to give you my business card.
The thing is, I frankly try to get the commissioning guy off the book, because commissioning ultimately is a snapshot of performance.
Yes.
And when things don't work, there are many variables or factors that affects it. But the problem is in the LEED, when you upload to the LEED credits,
Yes.
it makes you to say you ensure, you verify, you attest. So how do you suggest we how do we manage those, legal or insurance terms? We ensure, we verify.
Are you talking about the forensic fella
Oh,
going
both-
in,
both
or are you
sides.
talking about the entity doing the original commissioning?
What, when we do forensic commission, we end up verifying, ensure
Yeah,
performance.
you're identifying the observations that you made based
Right.
on the conditions you observed at that particular time.
Right.
I would think there would need to be some qualifying language along those lines, that this is based on the observations on this day, operating in this capacity, because every day is gonna be different. We don't know when the owner last changed the filters, we don't know any of that kind of stuff. Any of those things are sort of snapshots in time, and that is a very, very common practice to do the commissioning up front to see whether we've gotten what we thought we were gonna get. And owners then looking a year or so later at, hey, did I get my money's worth here? I paid, an extra $1 million to get this beefed up lead design, and I'm not seeing the savings I'm supposed to have.
The other question I have is with architects who are, architects by law can get $1 each